Hello everyone, my name is Brian Freeman. I'm the president of Workers' Compensation Lawyer Inc. And today I want to talk about another hearing that I'm going to be having today on the topic of Labor Code 132A. Now what is that? That is our statute in California that prohibits employers from discriminating against injured workers. And before I start talking more about it, I just want to read directly what the law actually says under 132A. I'm going to read this off of my laptop right here. It is the declared policy of this state that there should not be discrimination against workers who are injured in the course and scope of their employment. Subsection 1 then says, any employer who discharges or even threatens to discharge or in any manner discriminates against any employee because he or she has filed or made known his or her intention to file a claim for compensation with his or her employer, or an application for adjudication, or because the employee has received a rating, award, or settlement, is guilty of a misdemeanor, and the employee's compensation shall be increased by 1/2, but in no event more than $10,000, together with costs and expenses, not in excess of $250. Any such employee shall also be entitled to reinstatement and reimbursement for lost wages and work benefits caused by the acts of the employer. Now, what does that mean? That means the thing that I see happen all the time is illegal under California law. And what do I mean? I see this all the time. I see injured workers who, for example, work in a warehouse, make known that they've been hurt at work, and they tell their supervisor, I've had a work injury. And rather than do what they're supposed to do, sometimes the employer will tease or minimize the injury. Sometimes they'll fail to send the employee for treatment, even to their own clinic. And sometimes it's even worse. Sometimes I've heard real stories of employees being sent into a room to basically stare at the wall as punishment for being injured. All of these things, I would argue, are in violation of Labor Code 132A. The policy of the state is that we do not want employers retaliating or taking adverse action against innocent injured workers just because they got hurt at work. This is just my opinion at this point, but my opinion is that employers tend to misbehave against injured workers because of money. That's the bottom line, money. It costs an employer money when their insurance rates go up. And every time there's a new claim, there's a risk that that employer's insurance rates will go up. Some employers are even afraid that it could drive them out of business. Their insurance could be so high that they could not afford the legally mandated workers' compensation insurance. So to discourage psychologically their workforce from filing claims, some employers, I think, intentionally target the injured worker and try to make those workers quit. They make it so miserable for the employee that the employee does not want to stay, and understandably so. The employer has done what is called a constructive discharge at some point, where they make the working conditions so intolerable that no rational or reasonable person would want to stay and continue working there. And that saves the employer from the liability and risk of terminating someone if they can just get the injured worker to quit on their own. Now, today's hearing is about Labor Code 132A. I had an injured worker who suffered an unusual injury to the tailbone, and it happened because her entire job was sitting 8 hours a day, 40 days a week, always sitting, and some people are going to be predisposed to this type of tailbone injury. The employer denied it. They said, no, there's no evidence that your job would have caused your tailbone pain and your tailbone problems. It was something else. And through a lot of litigation, we had every single doctor agree, no, her injury is being caused and aggravated and exacerbated by the excess sitting she's doing for her job. A reasonable accommodation for the employer would be to give her a sit-stand desk, sit and stand at will. Now, the employer at first did accommodate this reasonable work restriction, but then out of the blue one day, they stopped and they would not accommodate. At that point, I believed that that was sufficient evidence of intentional discrimination. They were trying to get rid of my client by taking away that reasonable modified work, and they let her sit at home, do nothing. So that would be the question for trial. Did the employer actually discriminate against my client, or did they have other legitimate business reasons to not have her there? And that's why you need an attorney to do the proper legal discovery to find out the answers to these questions. Sometimes when there's violations of Labor Code 132A, there's also a civil violation under federal and state law. There's FEHA under California state law. There's the ADA under federal law. And when we think it has crossed the line, we make a referral to a specialist in that area of law. So all of our clients who suffer in this way, they get another consultation for yet another case. And we've seen many cases settle for a good amount of money when there's been this illegal discrimination. This not only a civil wrong, it's not only a workers' compensation wrong, but as you heard in the statute, it's a criminal wrong. It's a misdemeanor. If you believe that you've been the victim of harassment or discrimination after you've been injured at work, please don't ignore that. Call an attorney, see what rights you might have, see if we can help you and guide you in the right direction. Again, my name is Brian Freeman. I'm the president of Workers' Compensation Lawyer, Inc. You can reach us anytime at 844-428-4563. I hope that this information has been useful to you, and I hope that you are never the target of discrimination, but if you are, please give us a call. Thanks.